but that I had a concern that that is something that could happen in the future. In fact, it became a matter of dialogue between Mr. Hoskins and myself, because he wrote me a letter at some point in time saying he can't think of any theory like that either. But I was concerned that at some point in time, a taxpayer within the county might say to the city and council members, you gave our money away and you shouldn't have done that. And I said I couldn't come up with a theory, but I was concerned about that issue.
Did that concern arise in part out of the fact that, as you put it, you didn't think much of the anticipatory breach and constructive discharge?
I don't know that I necessarily connected those two thoughts. I think my thought was, in the grand scheme of things, the picture was, as I said, a divorce and a payment of a lot of money to one person for that divorce. And I was concerned that after the fact, that if somebody felt this was not a proper action for the board or the council to have taken, especially in light of my research that I've done on the contract claims, the Coward claim, that someone might pursue a cause of action against those councilmen.
Mr. Bright, you said that you tried to sketch a worst case scenario for the committee. Is that accurate?
Yes.
What did you tell them about the worst case scenario?
Well, what we talked about is we obviously talked about the allegations in the October 23rd letter. There was a contract claim. There were potential for tort claims, wrongful discharge, those types of things. And what I tried to share with them is, okay, if you were to lose, here's what the contract's worth, here's what the litigation costs could be going forward. There's always the potential if he's going to raise tort claims for compensatory and punitive damages. And so we would have discussed the fact that if Armageddon were to occur, this could certainly clear $2 million in exposure for the county.
Was that Armageddon number intended by you to be a valuation case?
No, sir. I was not trying to tell them that I thought they were on the hook for a $2 million. But as a good lawyer, I was trying to say that's always a possibility. It was not done on my part to parcel out each element of the claims and add them up and say, here's the exposure. I was merely trying to give them a big picture. He's certainly claiming this much for breach of contract. If he's claiming more for tort claims, if there's your expense costs and everything else, you could be talking in excess of $2 million.
So you started with his $1.2 million approximately demand.
The components of that, yes, and worked our way out from there.
Without factoring in any analysis of the likelihood of recovery.
This was not a function of suggesting to them the likelihood of recovery. It was merely expressing to them that this is a possibility. And in fact, I would suggest to you that I made it abundantly clear that I felt that the contract claim, in light of the research that I had done, was highly questionable.
At that first meeting on October 27th, did the committee give you any instructions or have any reaction for you at that time?
No, in fact, I can remember leaving, and I was impressed by the fact that it wasn't just the personnel committee. I had been instructed to deal with the personnel committee. That's the way we want you to communicate with the council. But I was impressed by the fact that Mr. Waldrop came, I believe Cindy Wilson came to that meeting, neither of whom were members of the personnel committee. And as the lawyer giving advice to the entire council and to the county, I was encouraged by the fact that they were there. But at the end of the meeting, I left thinking, I don't know what's going to happen next.
Was there then a second meeting?
There was a second meeting.
Between the two meetings, did your view of the merits of Mr. Preston's claim change?
No.
What do you recall about the discussion at the second meeting?
It was very much akin to the first meeting that we had, in that I was again reiterating the various five or six points that I laid out here a few minutes ago. And again, it was at that point in time that I was going to, they basically gave me my marching orders on what to do next.
And what were those marching orders?
The marching orders were that we appreciate what you've told us. We've taken that into consideration. We've decided that it's best for the county that Mr. Preston no longer be the county administrator, that we end this chapter, that's my words, not theirs, end this chapter in county history and move on. So Mr. Bright, we direct you to go and talk to Mr. Hoskins and try and get the best deal you can.
But did you understand that your assignment was to settle the matter?
Resolve it, that he was no longer going to work there. They were going to pay him some amount, and I was to find out what that amount was going to be.
You may.
Mr. Bright, Plaintiff's Exhibit 24, also pre-admitted, appear to be your notes of the November 10th, 2008 meeting. It says meeting with Joey Preston, but it appears that Rob Hoskins, Candy Kern-Fuller were there representing Mr. Preston, and you were there with Ellis Fisher from your office. Is that correct?
That's correct.
What do you recall about that meeting?
This was a meeting that was scheduled for Rob Hoskins' office. The point was to try and have a discussion about trying to have a resolution to separate Mr. Preston from the payroll, to find basically work out a severance agreement to end the relationship.
Was Gina Humphreys present at that meeting?
Yes, she was.
How did she come to be there?
I have no idea.
You didn't ask her to come?
No, sir, I did not.
And I think you testified previously that your involvement with Ms. Humphreys was that you received her calculation of the severance payment.
Correct.
What was your reaction to her presence there?
It was troubling to me in the sense that, and again, you have to understand the mindset that I come from, representing management in these kinds of relationships, is that she was a member of the management team. I didn't invite her to be there. I was surprised she was there. When I got there, I believe she was in the conference room with Rob Hoskins and Joey Preston, and that troubled me. I know I discussed it with either Mr. Wilson or maybe several of the members of the committee, saying, I don't understand this. But I don't think I really did anything about it other than express my surprise. It was disconcerting that she was there.
Was she there supporting Mr. Preston in terms of financial calculations?
That was the conclusion that I reached.
She hasn't laid a foundation. We know that.
We call for speculation at this point in time, if you can lay a foundation for his knowledge of why she was there.
Did Ms. Humphreys, to your knowledge, provide calculations to Mr. Hoskins or Mr. Preston or his team?
The only thing I can tell you is that I was provided by Mr. Hoskins with a spreadsheet that was very similar to what you handed me as Plaintiff's Exhibit number 15, except that it had a few more notations added to it, and I want to say the numbers went as high as $1.3 million. So the conclusion that I reached is that she had provided that to Mr. Preston.
In the course of this November 10th meeting, did Mr. Hoskins reiterate the demand that he had made in his October 23rd letter?
Again, and I can't remember the specifics, but my general recollection was something in the vicinity of $1.3 million was his demand. And the other thing I think it's important to understand is that at the point in time that I went into those meetings with Rob Hoskins, I made it abundantly clear to him, as I had to the council members that I was dealing with, that they had nothing in particular to offer to Mr. Preston. In other words, county government can only act in an open session of their meetings. So they hadn't gotten all the council members together to say, what do we want to do with Joey Preston? This was the personnel committee exploring possibilities and asking me to find out from Mr. Hoskins and from Mr. Preston what their offer to the county would be. And that was the approach that I took to the entire process.
So you had to go to Mr. Hoskins and say to him, in effect, would you take any less than what you've asked?
Well, when I had those discussions with him, yes.
Did that put you in a little bit of a negotiating disadvantage?
I would say a little bit, yes.
Did Mr. Hoskins, on behalf of Mr. Preston, move down much in his demand in the course of this November 10th meeting?
I don't know that it was in that meeting or if it was in subsequent conversations and phone calls we had later, but eventually the number came down to 1.1. And again, that's not an exact number, but it's round figures.
Let me direct your attention, Mr. Bright, to the second page of this Exhibit 24, the last line. After the November 10th meeting was over, did you make a report back to the Personnel Committee?
Yes, and I don't, in fact, this reflects that I talked to Mr. Wilson, I talked to Mr. McAbee, and I had left a message for Mr. Greer. So those were the three gentlemen on the Personnel Committee that I was reporting to. So I tried to keep them up to date on what had happened in that meeting.
What did Mr. McAbee say in response to you?
Again, I don't remember the specific call. I can tell you these are my notes. This is my handwritten notes from November 10th, and it reflects that he said to go ahead and give him the $1.3 million.
Well, Mr. McAbee, based on that, was prepared to settle at that level.
Yes.
Does that suggest that the $1.1 million number was arrived at sometime after this?
And then there's no, it's clear that it was.
After November 10th, did you talk to Mr. Wilson and get some more specific guidance from him on a target number?
I would have had to. I don't have a recollection. I know that I would have made notes of that in my file if I had. But most definitely I would have talked to him after that meeting. I didn't just leave it at one phone call.
Do you recall when your recollection of the $1.1 million number is in fact roughly consistent with what's in the severance agreement? Do you know when that number was arrived at?
I can tell you that, and I want to say that somewhere either on the 17th or the 18th, we were exchanging drafts of a proposed settlement agreement. So the number would have had to have been arrived at between November 10th and either the 17th or the 18th. I don't think it would have been as late as the 18th. It would have to have been before that. And again, understand that the way I postured this all along with Rob Hoskins is, Rob, this has to come as an offer from you. We talked about ballparks. We talked about possibilities and what is something that the committee felt they could put before council to be accepted. So these were numbers that were always coming from Rob Hoskins as an offer to the council. And that's the way I presented it.
But you had guidance from the committee?
Absolutely. Absolutely.
Was Mr. Wilson, as chairman of the Personnel Committee, the primary person involved in giving you that guidance?
Yes, he was.
At the time that the $1.1 roughly million number was being arrived at, were you asked by anyone on county council for your assessment of whether paying $1.1 million to settle these particular claims was a good use of county money?
No one asked me that question.
Did you have such an assessment?
I wouldn't have done it if it were me. But that was based on the research that I had done and shared with the county. That in fact, I didn't think this was an enforceable contract.
Did you were you primarily the drafter of the severance agreement?
I told Rob that I had, and again, most law offices have these, some form of a template that you use for severance agreements and the like, with things that we have tried over the years and been proven successful and permissible. So that's what I did. I took the major responsibility for drafting the agreement.
The severance agreement has been admitted, and I can certainly put it in front of you if it would be helpful to you in answering this question. But my question to you is with regard to the provision of the severance agreement, which is a covenant by the county not to sue Mr. Preston. And specifically, did you have any discussion with Mr. Hoskins about whether that language should be drafted to prevent a suit like this one challenging the validity of the severance agreement?
We never had that discussion, no.
When you were drafting, was that question in your contemplation?
That was not something we were contemplating. Again, what we were contemplating was a no-fault divorce. It was basically going to say, in exchange for this amount of money, you're not going to work there anymore. And the parties are not going to have anything to do with each other.
Yeah, approach the witness.
You may.
Mr. Bright, Plaintiff's Exhibit 26 has also been pre-admitted. It appears to be an email from Rob Hoskins to you dated November 17, 2008. Do you recognize that?
I sure do.
If you would look at the fourth and fifth lines, Mr. Hoskins writes, although I know that the agreement needs to be voted on tomorrow night and that the substantive figures are what is being considered, there are a few legal issues with regard to the final settlement agreement that I need to obtain consultation on. Did I read that correctly?
Yes, you did.
At least by November 17th, were you aware that there was a plan to vote on the severance agreement on November 18th?
I knew that the objective was to try and have the details worked out so that the matter could be presented to the full council on the evening of the 18th.
Did Mr. Wilson give you any instructions about whether or not you should come to that November 18th council meeting?
I know that he and I talked about it, and I offered, I said I'd be more than happy to be there. If you think that might help, if people have questions, you can certainly go into executive session of the council to have them ask me questions about any of the legal issues that are involved. Part of that was predicated on my concerns that they were paying this kind of money when I felt that there was a contract that might not be enforceable. But he said there's no need for you to do that. And so I did not attend.
Thank you, sir. Please answer any questions, Mr. Davidson.
Davis, before you begin that, we're going to take about a 5-minute break. I'll caution the witness not to discuss your testimony during the break with anyone. So we'll be in recess for about 5 minutes. Thank you very much.
July. No, I don't think so.
They're not as comfortable as they look. First 30 minutes.
I'm going to tell you, they're a lot more comfortable with us.
You're right about that. I've sat nose to it. This travel bad? Yeah, it's about the first 30 minutes, it's all right. After that, none of it starts to set in. Just check. Oh, you this face, right? Probably made it right off.